Hello, everyone. I'm Peter Coy. I'm the past president of the New York Financial Writers Association and the host for this evening's event, which is on freelance law. And we have a great pair of speakers this evening. Gena Usenheimer is a partner in the labor and employment practice of Seyfarth Shaw LLP, a law firm with about 900 lawyers across 18 offices, and she represents employers in employment issues. Um, and Originally, we had Rafael Espinal, the executive director of the Freelancers Union, but he couldn't make it. So we have a very able replacement, Meredith Tannor, who is the policy director of the Freelancers Union and is intimately familiar with these issues, of course, from the perspective of the freelancers themselves. So we have a nice contrast there. And I think it's going to be a great event, and really educational for our members and anyone else who chooses to tune in now or when now or listening to the recording. So I think I want to get into the nuts and bolts of the employment of the freelancer law. But before I do that, I'd just like to have each of the speakers introduce herself. And I'll start with Meredith. Meredith, tell me about yourself, but also about the Freelancers Union. Why do we even have a Freelancers Union, for example?
Yeah, hi, great to be here. So I am the policy director for the Freelancers Union. A large part of my job is implementing Freelance Isn't Free across the country, amongst various other legislative bills in support of freelancers. And that's a large part of what the Freelancers Union does, is we try to advocate and push out the agenda for freelancers who have largely been left out of this social safety net. So when it comes to health insurance and paid leave and contracts and just protections overall, the Freelancers Union does that advocacy and legwork to make sure that all of the voices of freelancers are heard. Beyond that, we also have resources um, and provide health insurance. So while we're not a traditional union, we function as a quasi freelancer union just because it's very hard to unionize and can't unionize
Interactive.
freelancers.
Okay, Jenna, please tell me about yourself.
Yes. So as Peter mentioned, my name is Gena Usenheimer. I'm a partner at a law firm called Seyfarth Shaw. We're an international firm. We have hundreds of attorneys and offices all over the world. I have been practicing labor and employment law for about 19 years now, and I represent employers and, in this case, hiring parties almost exclusively. But my practice for many years has focused on not just traditional employment disputes, but has expanded to cover issues which reach independent contractors, misclassification, the way that independent contractors interact with their hiring parties, so to speak. So when the city law came out and now the state law came out, it's really fallen right into my wheelhouse. So I've been able to get up to speed very quickly and written articles and the like about the topic. So happy to be here.
Okay, so the reason for this session, of course, is to talk about the law, the Freelance Isn't Free Act, which Kathy Hochul signed into law last November. And it took effect, I believe, just the end of August of this year, if I'm right. And it follows on a New York City law, the same name from 2017. So I just think I should ask, 1 second, please. We'll start with Meredith. Could you tell us about the law a little bit, what protections it gives, both the New York City version and the New York State version?
Yeah, so um, if you're living in New York City, then you'll file with New York City just to start. Or if you're outside of New York City and you're in the state, then you'll file with New York. It guarantees contracts for anything over $800 within 120 days. So if you are working as a graphic designer for a company, then you are rightfully owed a contract. And in fact, it's mandated by law. And the goal of this law is to protect against non-payment. So what the Freelancers Union has done is created data and surveyed our members to figure out how many freelancers have not gotten paid. And we came up with a number that was 74%, which
Wow.
is startling and disappointing to know that 74% of freelancers have experienced non-payment in some form. Some people, it can be as little as $50, and we have members who have not gotten paid for over $150,000 of work. So what this law tries to do is make sure that there is a contract in place, and then there is a mechanism to complain and create and file a complaint against the hiring party that has taken advantage of the freelancer and not paid for the work and the payment that is rightfully due. So if there is no contract in place, there are 30-day payment terms. So if a freelancer doesn't have a contract, then in lieu of the contract, then you are rightfully owed payment in 30 days. And then going beyond that, there is enforcement. So in New York City, you can file with the Department of Consumer and Worker Protections. In New York State, you can now file with the Attorney General Letitia James' office. And what happens if you do is they send a letter on your behalf, essentially saying there was a complaint filed, please respond to the complaint. If there is no complaint filed, if there is no response, then the freelancer is given a letter that there was no response, and this you can use in small claims court. And if there is a response, then you can also use that in small claims. But for the most part, what this law has been really good at is intimidating, hiring parties who are bad actors, right? So that you don't need to go to small claims court, because the hiring party has no incentive to go to small claims court if everything is, or civil court if it's larger. If everything is as said, then the hiring party has more incentives to just pay. So yeah, that's Freelance Isn't Free.
Very good. Gena, what's your perspective on the law?
Well, I agree. I agree with Meredith. I think that the law is clearly intended to facilitate payment to freelance workers. I would say that, one thing I would say that I would just give everybody a heads up that while the law on its face says exactly what Meredith said, that you have to give a contract to a freelancer who's engaged to perform services or goods or services for $800, either individually for the one project that you're engaged for, or in the aggregate over the last 120 days, just what she said. If you do not get a contract, that is actually not a basis to file a claim under the state or the city law. So you have to make sure that you ask for a contract before the work begins. That's the hook that's going to get you really what you need. But leaving that aside, if you do have a contract and there's some form of non-payment, or there's some form of intimidation or discrimination or retaliation, which are laws that really typically don't extend to independent contractors, or sometimes they do, but it's not been a traditional protection afforded outside the employment scope, you now have a remedy. And I completely agree with Meredith's point that this is a really, it's not just a remedy like going to court or small claims court. You have an avenue to an administrative system within the state and the city that frankly is really designed to protect your rights and is going to advocate on your behalf. And I think the best example of that is that under both laws, the hiring party is not permitted to make a claim with the Department of Labor or the city agency. Only the freelance worker can. So this is a system that is really designed to make sure that if you have a contract, that the terms are met and to your benefit.
Gena, explain to me again why the lack of a contract is not a cause of action, since there's supposed to be a contract.
Peter, that is a really great question. I would say that in both the city law and the state law, which is heavily modeled off of the city law, it says very clearly you need to have a contract, and the contract needs to say all these things. And then when you get to the remedy section, it says, okay, well, if you don't have a contract, you can file a claim, but you can't state a claim and you can't recover unless you asked for a contract and you didn't get one before the services began. So it's, it's a little, it's not so clean cut, I guess I would say there.
Yeah, okay.
If I may, I would actually argue the opposite. So Gena, would love to speak to you more about this at another time, or I guess we're going to do it all here anyway. But so the providing a contract in both laws actually does fall on the hiring party. So you can file a complaint for not receiving a contract, even if you didn't ask for one.
Well, we can maybe talk about it afterwards. But the way that I read, at least the New York State statute, is that if you've requested the contract before work began, then you're entitled to statutory damages and you can bring a claim. But I think leaving aside the varying interpretations, I think the crux is typically you're not going to be bringing a claim just for the fact that there wasn't a contract, right? You're going to be bringing a claim for the fact that you didn't have a contract and you weren't paid correctly, right? And that's the heart of the issue. And that you are free to do whether or not you had a written contract. And Meredith is exactly right that the responsibility falls to the hiring party. So if you are a freelance worker and you have, let's say, a verbal agreement to provide certain services and it's not memorialized to writing, and then you take advantage of some of these complaint procedures under the statute, if there is no contract, it is the hiring party's burden. And so if they fail to provide a contract like they're supposed to under the law, your recollection or your understanding of what the terms of your agreement were are largely going to control. And so that is a much more favorable enforcement mechanism for you that you might otherwise find, such as in small claims court.
Okay, very good. We have a first question from Greg Miles. He asks, all these new laws protecting freelancers are nice, including requiring contracts, but how good are New York regulators in following up and enforcing these laws? How quickly do regulators act, and in what % of the time do freelancers get paid now versus 5 to 10 years ago?
I can speak on this. So we work very closely with the Department of Consumer and Worker Protection in New York City. It is way too soon to see the actual statistics and how effective it is in New York State, given that it went into effect about a month ago. But in New York City, there's been over, I think, 2,500 complaints filed. And they have recouped, I think, just a little bit over $3 million. And that's in self-reported numbers for the money that has been recouped. So the numbers likely much larger than the $3 million. And what has been so great about the law is that people don't have to actually go back and tell and go to small claims court, right? So that's why we don't know the exact numbers, is because the clients and the hiring party is just paying, right? Versus before the law went into effect in 2017 in New York City, there was no private right of action. There was no mechanism in place to file a complaint or have this, I'm going to call it intimidation factor, which isn't the right term, but essentially is to scare the client into paying, because there was no reason to pay if there was no recourse on behalf of the freelancer. So it's been largely successful. In fact, the city went after a large company, L'Official, who had a pattern of practice. And that's another aspect of the law, is if there are multiple complaints filed against a particular hiring party, then it's a pattern of practice. And then the city or state agency can go after them in a different way and pool all of these freelancers together to file a court case and go after them. And so I think everyone under the L'Official received about $40,000, and that included double damages and their legal fees, which is also stipulated in the law, is if you win your case and it does end up going to court, then you get double damages and you get your legal fees recovered as well.
Yeah. Gena, I want to ask you, I think you have an audience of journalists and freelancers, and probably mostly sympathies probably lie more towards the freelancer side of things. But what's your perspective as representing employers in these cases? Is there some, when you're defending them, what's typically the defense?
Well, actually, I would say I don't think that we've really seen much in the way of to be frank, litigation over amounts that are substantial enough under these statutes to compel engaging counsel, or certainly me or my firm yet. But, you know, I actually don't see that there's a big, like, delta in the sympathies on this one. You know, I think everybody understands, and hiring parties, at least sophisticated hiring parties, right? And I think Meredith is probably better able to speak to the kinds of hiring parties that maybe are often not paying or violating terms of agreements. But I think sophisticated parties, contracting parties in New York at least, are probably, you know, nobody likes additional regulation, but in some respects, you're happy to know what you need to do. Like, there's a rule, we're going to follow the rule. The Department of Labor in New York State has issued model contracts. New York City has model contracts. I certainly have my feelings about them, which probably wouldn't, Meredith and I probably wouldn't agree on all the terms in the model contract, but it gives you like a construct to work through, right? And the freelancer knows what to expect, and the hiring party knows what to expect. And I mean, most often I think if there's plain payment terms, it's kind of hard to defend an absolute failure to pay unless there's, you know, extenuating circumstances or a quality issue or some other extenuating issue.
Interesting point you made there about model contracts. What are provisions in a model contract that you might not like that Meredith might like?
Yeah, I'm curious as well.
So, you know, as, you know, I know we get a bad rap, but lawyers, we try to really limit the contractual obligations that our clients sign that go beyond what's really required, right? Because it's just imposing additional burden. So both the state and city law require certain elements be in the contract, and I'm not looking at my notes, so I'm not going to remember them all, but essentially it's like the name and address of the parties, the scope of the services, you know, how you're going to figure out the method of pay, when payment is due, or if there's not a date, perhaps there's a process to figure out when payment's due, and things sort of that nature. So the New York City model contract is 4 pages long. It includes those 5 or 6 important bullet points. Actually, the city one, I think, is a little bit better than the state one. The city one then goes on to add 2 more pages worth of provisions, but it's very clear, right? Like, this is optional. Do you want to have a intellectual property assignment provision? You can or you cannot. Do you want to have language about late payment fees? You can. It's very clear what's optional and what's required. So that's a 4-page contract. The New York State model contract issued at the Department of Labor is, I think it's 6 pages. It's 6 or 8 pages. I can't exactly remember. It's much longer. It includes lots of provisions that fall outside the 4 corners of the statute. Now, maybe they are a best practice for contracting parties. That is entirely possible. But, you know, it goes well beyond what is required by the statute. And there's no indication of what's, you know, optional or voluntary. So, and I think some of the provisions, frankly, really are, they're not just things like, you know, choice of law and, you know, what are we going to do about termination provisions, things like that. I mean, they really go pretty far afield, in my opinion. But I'm sure Meredith disagrees. So, Meredith, what do you think about the model contract?
I disagree. I mean, we had a hand in the New York City and the New York State to a degree. But
I like the city. I think the city contract was better than the state.
What's great about the optional terms is it's really an educational tool, right? It's about freelancers learning what can be added to a contract. I would say most of us have been on the other end of a contract where we don't actually know what we're reading. And so hiring parties often put all of these terms and additional clauses in our contracts. And so it's about time that freelancers and the workers are able to kind of do the same and understand their rights. So when it comes to, yes, let's say kill fees that are in the model contract. Many people don't know what those are. Those are for writers, right? If you're working on a project that's taking 2 months and at the end you're supposed to get paid X amount, but the project is killed in the middle of the assignment, you've been working on it for a month. You've been doing the investigation or the writing or whatever it is, you are rightfully owed based on the contract. And just kind of understanding these various terms, which everything is variable. In a contract, it's what you make of it, right? If it's written down, then that is the contract. We live in a world that is constantly evolving. Now there are AI aspects to take into account that might need to be added into a contract. It depends on the job, and it depends on what you're looking for and how you need to be protected. And that's what these model contracts are really good at. It's not to take these contracts and plug and play and, you know, put your name and fill everything out and serve it to your client, but it is more about understanding what you can use in a contract, what you can use against a hiring party if you so wish. But yes, Gena is right. What is mandatory under the law is really just scope of the work, it's payment terms. So that's whether you're supposed to get paid in 14 days, 30 days, 7 days. It is, yeah, your name and address, because in New York City and New York State, you need the address of your hiring party in order to serve a complaint. And that's pretty much it. And that can also be a text or an email. It can serve as a contract. If someone is writing this all out in a text or an email, that serves as proof of terms of service, essentially. So while, yes, mandatory contracts can get a little confusing, hard to understand, hard to do on behalf of the freelancer, anything that is written in a text, if someone is like, I will pay you $600 to write this article, then that is your contract.
Just a question maybe for either of you on following up on exactly that last point you made, Meredith. Somebody sends me a statement about what they want me to do, how much they're going to pay me, etc. If I don't respond to that by saying, yes, I accept those terms, is it still a contract?
I would argue yes. I think Gena will argue no, but yes. A contract doesn't necessarily require a signature on behalf of both parties, especially under this law. That is stipulated as a contract. And if the freelancer then sends over the work and is like, here's my work, here is my invoice, then that is essentially an agreement, right? No one is saying that you received a text saying you're supposed to get this for this amount of work. If you don't do the work or whatever it is, then no, that's not agreement that you're just going to receive this money. But if you are then providing the actual services and you're providing the invoice for the services, then that in itself is an agreement.
Yeah. I mean, it's been quite some time since I was in law school, longer than I'd like to admit. But, you know, I absolutely agree. You don't need a signature to have a contract, right? You could have, I mean, this law requires a written agreement, but we could have a verbal contract that in some circumstances, right, would be enforceable. So, but the important, I think, in your hypothetical, Peter, you know, the basics of a contract, right? Offer, acceptance, consideration. So you have to have some overt act or indication of some sort that you are accepting those terms, right? So my response is somewhere in between what you both said. So you know, you want to accept the contract and then you deliver the work and then you get paid, but that you need to have some sort of acceptance. You can't just have a, you know, receive a text message and then have a contract.
And it's pretty unlikely, right? That you're just going to receive a text and it's going to say all these things and you're going to be like, okay, cool, I'll get this to you eventually. You're probably going to say something along the lines, great, looking forward to working with you, or this number doesn't work for me. So that would be a different hypothetical, but it is more likely that someone would respond.
Okay,
and the law specifically, I was going to say, sorry, Peter, that the law specifically contemplates an exchange of a contract either in physical or electronic form. So it very specifically contemplates what Meredith was just talking about, a text or an email.
Got it. Okay, we got a couple more questions coming in. I'll take them one at a time. David Rodek asks, do these laws only apply to New York-based clients, or can I apply them to clients in other states? Given the world of remote work, I'd say only 20% or so of my clients are in New York.
So I can take that one. So that is one of the beauties of this law, is that only either the freelancer or the hiring party needs to be based in New York City or New York State. So if you're a freelancer working in New York City and your client is in Nevada, then the law still applies, and vice versa. If you're contracted by a hiring party that is in New York and you're in Nevada, then it still applies as well.
Okay, that's straightforward. And John Jacobs asks, what happens if the payment was specified as and David says, wow, that's awesome. Thanks. So thanks he's happy. All right.
We were happy about that one too.
Yeah. John Jacobs asks, what happens if the payment was specified as a percent of revenue from sales of a book or other product?
Yeah, so going back to the model contract, right? It's what's in your contract. So if it is revenue percentages, and things of that nature, that should all be written in a contract, especially if it's for a book. You want to make sure you have the best contract possible. But if you're essentially a freelancer or an independent worker, then the law still applies. Gena, you might have more experience with this kind of contract.
Well, I agree. I mean, I guess maybe I'm not so sure what the question is. I agree. Whatever you're going to write the percentage in the agreement, you're going to write the method of calculating the percentage. You obviously want to make it as specific as possible, like Meredith was saying, gross sales, net sales. And then, but I don't think that I don't think the law applies or the enforcement mechanisms are different if it is like an hourly rate or like a project rate or a percentage, if that's the question. I think the law applies in the exact same way.
Yeah, in fact, the law is broad enough to like freelancers and independent contractors that it's, again, not a specific industry, right? So if you're a author writing a book, then as long as you can claim that you're an individual creating these services, then the law applies no matter how you get paid.
Yeah. I want people to keep asking questions, but meanwhile, I want to go to Meredith and ask you just a little bit more about the Freelancers Union. As you explained at the outset, it's not a conventional union. You don't do collective bargaining. But how did the organization come about? How is it supported, et cetera?
Yeah, so it's changed a lot over the years, and I haven't been there since the start, which was 1995. But it has, at its core, the union has been about protecting freelancers' rights. It was started by Sarah Horowitz, who was a freelancer and noticed these issues. And specifically, we started more as a union or a organization that supported freelancers with health insurance. Given that it is such an important issue for self-employed workers, who are largely left out of obviously any employer benefits model. Creating an affordable healthcare model is what the Freelancers Union's mission was at the get-go, on top of advocating and providing just resources and services. So we were the ones who were creating those model contracts and providing those to freelancers, and then providing health insurance and the advocacy and all the rest. And then also partnering with other organizations who hold our ideals to offer further services, whether it be 401ks or liability insurance or invoicing softwares and all the rest. But
And you have supported by where does your support come? Is it partly from the freelancers themselves?
yeah, I mean, we are a nonprofit organization, so a lot of what revenue we generate is from freelancers. It is still in insurance to a degree after the Affordable Care Act. The insurance model we had to change, so we do receive from insurance, but then more than that it has been largely from New York City. In fact, so we operate a free co-working space in Industry City, Brooklyn, for freelancers to come and work whenever they want. We also have a free legal clinic where if freelancers in New York City, we serve all 50 states. The organization is national. But freelancers in New York City who have an issue with a client can come and file a complaint with us, and we can get you in touch with a lawyer. If you're outside of New York City, we can still take those complaints, provide all of the resources and advice that we have, and then connect you to a lawyer. While it won't be free to then give you those legal services, that is a large part of what we do, is just trying to give resources to the freelance workforce.
Okay, great. A couple more questions have come in. David, Greg Miles asks, what are the key mistakes that freelancers most frequently make in signing and creating these new contracts, and how can they avoid these missteps?
Yeah. So a key mistake is payment terms, right? Not really understanding how they work or when to put them out, or like if you're getting Venmo or check, or when the invoice is sent, if it's after the invoice is sent. Again, just stipulating everything that you want to see in a contract is really important. And then I would say on the creating side is that you're not including enough. There are so many times, again, where a project is canceled in the middle and you don't know what to do. The hiring party is saying, we owe you nothing. Even though you did some work, we weren't paying you hourly. We were paying you for the project or the book or the article. So you're owed nothing. So really keeping all of those things in a contract, and then just making sure you're looking over the contract. If you're given a contract, when it comes to writers, making sure if it's copyright or how they're able to use your work, if they're able to take your work and alter it or sell it, or train AI models with it. Just really reading through these contracts to understand what they're doing with the services that you're providing.
Just sticking on the kill fee, since that's I guess a common issue that comes up. How would you structure a kill fee for a situation like the one you described? The project gets canceled, you've done some work, but you didn't really complete the job.
Yep. So definitely having a clause in the contract that's saying, if, let's say, the due date for the work is supposed to be in a month. If you're at 14 days, and again, all of this is variable, so it depends on what work you're providing. So if you're at 14 days, you can say you are owed 50%. And you can put that into the contract. So if your contract is canceled before the end of the term, then you're owed 50% of what it was originally worth. Or if it's a certain amount of words, let's say, if you wrote 2,000 words, then you are owed X percentage or X dollars, right? It's all up to both the hiring party and the freelancer to negotiate those kill fees. But knowing that, especially for writers, it's really important, because we know that this happens frequently, that you're working on something, you're working on a story or a book, and someone decides that we're going in a different direction. Negotiating that and understanding that you have the right to include that in a contract, whether it be half of what's the contract is worth or 20% or whatever seems reasonable and fair for the amount of work and energy and effort that you put in to the project already done.
Yeah. Catherine Hares asks, in past years, I wrote for an organization as a freelancer and never signed a contract with them regarding ownership of these articles. Can I assume that I retain ownership of that work? I'm going to go to Gena first on this one, since she hasn't had a chance to talk for a little while.
Okay, great. Yeah, somebody just put a comment, work for hire. You know, I'm not really an IP lawyer, so I would feel very uncomfortable speaking intelligently on who owns those IP rights. Meredith might have more day-to-day knowledge on that, but I do tend to think that if you are, I mean, I'm not sure if work for hire actually applies in the independent contractor context. So Meredith might have more.
Copyright law is tough, and yes, work for hire is super important. And so I would assume that in lieu of a contract, you can that you own the work that you produced. There is nothing stating otherwise, and if there is a clear proof and like handoff of the work that you created, then it is your intellectual property. I am not speaking on specific law here, but I think there is a very clear argument that you retain ownership if not stipulated otherwise.
Okay, well, I can imagine that being litigated. As Catherine writes, I agree that it is my work. I never signed anything indicating that the work was work for hire. That's your point.
Yeah, if the work was paid for, that could also cause some complications. But again, if there was nothing that said that you were giving over your copyright or your ownership to the work, then I would assume that the law would come down on the freelancer side in this instance.
Yeah. So, Gena, would you say, from what your knowledge, that New York is in the leadership, is in the lead among all 50 states in terms of protection of freelancers?
Well, we don't want to make our friends in California feel badly about that. So New York City, New York State, New Jersey, California, and a handful of other states, just generally speaking, are very, very aggressive with workers' rights, regardless of like independent contractor or employee at the forefront of protections. I mean, I think New Jersey has really been surprising us all in the last few years of how progressive it's become, even outpacing California and New York. New York City is obviously a very protective jurisdiction. So, I mean, we are certainly at the forefront, but you know, I'm sure if Meredith's job is advocating this law in all of the states, she can certainly give more specifics about the terms in other jurisdictions. But New York is very progressive, so it's a good state to be in or to be working in, certainly as an independent contractor or freelancer. There's a lot of protections available.
Yeah, and to build on that, so the law actually just Freelance Isn't Free, it goes by a different name in various jurisdictions, but just past Saturday night into law, Governor Newsom signed it in California. So that was the third state to go online.
Yeah.
Yeah.
Doesn't want to be left behind. Yeah.
They were the third, but it's also available in Los Angeles. And then Illinois State was the second state. For a second, New York got a little complicated there with the sightings and going into effect. But so those three states all have Freelance Isn't Free. And then various cities, including Seattle, Minneapolis, Columbus, Ohio, as I said, Los Angeles, New York City, and then the Freelancers Union has, and various state legislatures and city legislatures have a similar bill in New Hampshire, Georgia, Missouri, Kansas. We're working on Philadelphia and Austin, Texas. And I might be forgetting a couple. And then overall, we're really hoping for a federal legislation on these issues. New Jersey, even though, yes, big on workers' rights, again, freelancers' rights are often left out of the conversation. So while misclassification is constantly sucking up airspace, normal everyday freelance issues like non-payment or being exploited or retaliated against is left out of the conversation. And New Jersey it has been introduced 3 times. On the last time it passed the full legislature, but then was pocket vetoed by the governor. I don't think that there was any true intention to hurt freelancers other than budget, but we will be also pushing for New Jersey to include this in the next legislature.
You really open a can of worms when you mention misclassification, right? That's a whole other issue.
Yeah.
Maybe Gena has some thoughts about that.
that's a whole other, presentation.
Yeah, but it is something that's of concern to people who are working and they're not clear, well, am I an employee or freelance here, right?
I mean, I would say just generally speaking, there's a lot of confusion around whether or not somebody is an independent contractor or an employee. I mean, not my clients, but you would be surprised the number of people that I just bump into who say like, oh, but they're an independent contractor because we signed a contract and the contract says they're an independent contractor.
Can't just say it.
Yeah, that's not how it works, right? It's like it doesn't matter what label you put on it. You can, it's what the actual reality of the business relationship and the engagement is. And I think that is still very hard for people, I think on both sides, to really understand, because often people want to be paid as an independent contractor because there are tax benefits or they feel that there's a benefit to them for some other financial reason or otherwise. And so it's not even the hiring party always who's asking for an independent contractor. Sometimes it's the worker who's providing services. But yes, I agree it is very messy. And certainly if you were talking about, huge populations of workers who are misclassified, it is very problematic all around.
Meredith, is misclassification one of the issues that your union deals with?
I mean, yes, we get lots of complaints and we are always part of the conversation. It's misclassification and the way that we've kind of been going, and I will kind of talk about my own personal opinions here, around these misclassification topics, is it does include, as Gena said, a bunch of workers who do want to be independent contractors, right? Who do want that flexibility of work and don't actually want to be looped in. And we've seen the chaos in California with AB5 and the subsequent bills that were put in to like clarify and then cut out, the gig workers who are actually supposed to be included. But for writers, it's really tough, right? A lot of writers do want full-time employment. They do want to work for the media outlet or wherever it is. And I think we just, as a whole, need clarity on misclassification and what is the right standard, because it varies by state, it varies federally, and we really need to work towards something all uniting behind a proper legislation that represents everyone. I believe strongly, again, personal opinions here, on a portable benefits model. I think that despite being an independent contractor, or even if you're misclassified, like everyone deserves some kind of benefits model. We know the prices of insurance. We know that freelancers don't get time off if you're having a baby or you're sick. It's just money gone, even though you work harder than many full-time employees. Creating a benefits model that represents all workers, given that traditional employment is changing, is going to continue to change, and we need to be very inclusive of the future of work.
Definitely, definitely. Catherine has a very practical question. Catherine Harris, is there a standard contract that freelancers should use as a base document when seeking work? Does the union offer such a document that a writer can serve up to a potential employer?
Yeah. So what we were speaking about earlier was there is a model contract in New York City and New York State and all the other jurisdictions where this law exists. But beyond that, the Freelancers Union does have a contract generator where you can put in your name. Gena, I know you're going to look for it now and tell me everything that's wrong with it, but it is. We released this back in April, so I will send around the link. So you can create a document, a Word doc, or a PDF, so you can change it as needed, put in what you need. It just kind of has all those optional terms that might be relevant for you, but just gives you an outline of a contract. And so I love it, but again, it's a work in progress. And as we know, and I've mentioned earlier, freelancers are in so many different industries that it's really hard to create a contract that encompasses all these various terms that might apply. So if you have any recommendations or thoughts, there is a survey that goes directly to me that I would love to hear any suggestions or ways that our contract generator kind of fails or misses some places. Yeah.
Folks, we're going to wrap up pretty soon, so I want to make sure you get your questions in now while we still have a chance. We have a couple more people coming in. Catherine Harris again, editors sometimes get angry if you say you want to bring a lawyer into the mix. Gena, what do you think about that? How would you handle that?
How would I handle that as a freelance worker who's trying to negotiate a contract? Look, I think, you know, you really have to make it, I think, the decision that's best for you. You want to advocate for your legal rights, but I think you have to decide, you know, what's going to be the most successful for your economic needs, right? So I think that all these benefits and tools and learning products that Meredith and her union offer and the information that's available publicly can put you in a position where hopefully you are on more even like bargaining power and more even footing with the hiring party, right? But it can't really give you specific advice about whether or not to bring in a lawyer with you. I mean, if you feel like you're best served doing that, then, you know, you should listen to your sense of what's going to serve you best.
If I can just add on that if a hiring party does say that they don't want to work with you essentially because you're negotiating a contract or anything or you want a contract, that is what the anti-retaliation is for, that is baked into these laws, is to prevent a client from retaliating if you request or address your rights under the law. So if they refuse to give you a contract and instead say they don't want to work with you, maybe it's because you brought a lawyer, or you're asking for a contract, or you're saying that non-payment is against the law, then that is what the anti-retaliation clause is for. So it's scary to invoke that as a freelancer, you know, and to even bring that up, it's like, I get it. It's all of these things. Yes, even though you're protected under the law, you're still working for yourself. And this is all still scary, especially when you're going up against like big business and you're, you know, a little guy, or, you know, just standing on your own to even say you're violating the law. But there are consequences and there is actions that you can take in those circumstances.
Yeah.
And even adding to that, I mean, Meredith can tell me if I'm wrong, but the way I read the statute, that the retaliation provisions don't only apply to the hiring party that was contracting with you. So they can't tell their friends, and then another company won't work with you because you tried to enforce your rights in the first situation. So they're a pretty robust anti-retaliation provisions in the statute.
I have one question from David, and this might be the last one, unless somebody wants to squeeze one in under the wire. It was about the PRO Act. And he says it seems well-intentioned, but could be a problem for freelancers operating as a business. Your thoughts on that?
Yeah, this is kind of this is what I was trying to get at earlier, is that the PRO Act or AB5 or all of this various misclassification laws, they're all well-intentioned, right? They're trying to ensure that workers receive benefits and receive timely pay and receive all of the things that come with being an employee. The issue with all of these is that it's not one size fits all, right? No worker is one size fits all. And I agree, PRO Act is well-intentioned and I agree with it in so many ways, but I also understand where it is lacking and where freelancers and small businesses feel as though they're being looped in to a group that they don't actually want to be a part of. And I think what's good about the PRO Act is it's putting a spotlight on these issues, and it's creating this discourse for us to discuss, like what is wrong, why it is failing in some ways, to create a better model. So I don't think we're there yet. And again, well-intentioned, but we still need to figure out something that works for everyone.
Okay, any thoughts, Jenna?
No, I agree. I mean, based on my understanding, I can see why some legislators think it is a solution, but I understand the point that it is a one size fits all, and perhaps one size does not fit many in
Right.
particular.
All right. Well, I think I'm going to wrap it here. We've covered a lot of ground, and we had two very knowledgeable speakers, Gena Usenheimer and Meredith Tannor. Thank you both for joining the New York Financial Writers Association.